afternoon, dear students. Today we can lawyers, and now I present you for you new topic, which named logical analysis of concepts and legal concepts. I propose you four questions. For the first, concept as a form of thinking. Types of concepts in scope and content, content of the concept and composition of the crime, and logical relationship between concepts. So, in our daily life, we use various types of concept every day, every minute. And especially very important in our professional life, professional activity, know various concepts, nature of concept, kinds of concept, and logical relationships. Relationships between these types of concepts. So the concept is called a form of thinking, one of the kinds of forms of thinking, which reproduce objects and phenomena in their essential features. From this definition, it follows that for the first, the concept is an imaginary image of an object, its reflection, and not itself. Therefore, the concept of objects can be confused with the very objects that are reflected in these concepts. Concept is a logical form of thought, an idea of an object. The subject of thought is the object or a phenomenon that a person thinks about. Subjects of thought can be both material objects and phenomena. So, and thoughts about these objects that exist in objective reality around us. And objects and phenomena are represented like a god, like water nymph, and other specific concepts. Second, the concept does not reproduce all that has an object, not all of its features, but only significant. The signs are all the things in which the object are similar to each other, or what is different. The signs are some types, like significant sciences, insignificant, general, and excellent sciences. Significant signs. There are signs that reflect the nature of the subject, its essence, and distinguish it from all other objects. Significant features are common and also necessary signs, such as those that belong to all kinds of things and which the subject is unthinkable. Significant signs are signs that presence or absence of which does not lead to a change in the nature of the object or phenomenon. Unimportant signs are signs unstable, external, individual, which don't express the properties of the subject. So the difference between essential and non-essential features is relative. Among the set of significant signs, distinguish classes of general, single, and distinctive signs. General, single, and distinctive signs. So, significant signs common belong to many subjects. So, single is a specific to a single item only, and excellent signs distinguish the subject among many homogeneous. For example, Aristotle, a human, ancient Greek philosopher, founder of logic, author of Analysis. The concept differs from the imagination. The imagination, as well as the concept, reflects the subject in its features. Only the concept reproduces essential features and imagination, and object in the aggregate of the most diverse of its features. The imagination is richer than understood. It reflects a great number of features of the subject, but comprehensively reflects the object, and it gives us knowledge about the property of the subject, while the representation of the properties of things and phenomena does not reveal. In the process of formation of concepts, use such logical ways as comparisons, analysis, synthesis, and abstraction. So, for the first, the analysis, like most simple type of the process of forming the concepts, called the thought division of the object into its constituent parts. So, synthesis is the imaginary combination of parts of an object dissected by the analysis into a single whole. Analysis and synthesis are in inextricable unity. They are interrelated and interdependent. Analysis always allows synthesis and synthesis to analysis. Comparison is a logical method for establishing the identity or difference of objects by their characteristics. The comparison makes it possible to identify the total of the objects, what they are similar to, and how they differ, to evaluate their identified signs, to group objects into classes, and so on. Abstraction is an imaginary separation of the essential features of an object and separation from the mass of other attributes. And generalization is a logical way through which an imaginary transition from unit to general occurs through the union of homogeneous objects into classes based on their common features. So, next question, types of concepts in scope and content. Any concept has scope and content. What is the content of the concept? The content of this concept, a set of existing features of objects reflected in the concept. So, the content of the concept is to become signs that reproduce the quality of the subject and some distinguish it from other similar objects. Thus, the content of the term agreement is a set of such features. 1. Action aimed. 2. Establishing. 3. Change or. And 4. Suspension. And 5. Civil relations. So, agreement is action aimed establishing change or suspension, civil relations. So, the content of the concept can be established, expanded only by means of the definition of this concept. So, the scope of the concept is a set of objects or phenomena, deliberate rationalization. The scope of the concept is the range of objects on which this concept is distributed. For example, the scope of the term state, yes, state, all states. The scope of the concept of theft, all crimes with signs of this concept. The set of objects that make up the scope of the concept is called a logical class. So, separate single items of a class are called individuals or elements of the class. For example, the city of Kiev is an element of the class of all cities in Ukraine and in the world. The content and scope of the concepts are interrelated. This relationship is expressed in the logical order of the inverse relationship between the scope and content of the concept, which is formulated as follows. With the increase in the content of the concept, decreases its scope, and with the increases in the scope of the concept, decreases its content. So, thus, a large scope, less content, and more content, less scope, according to this principle. Let's make two concepts, crime and official crime. A large amount has the concept of crime, since it extends to all crimes, and the term official crime covers only a part of all class types of crimes, those that are official. The content will be larger in the notion of official crime, as you mean, because apart from the features inherent in all kinds of crime, it also included specific features, those in which the official crimes are different from other type of crimes. By scope, concept are single, common, and zero concept. So we have three general types of scope concepts are single, common, and zero. So a zero term is a concept whose logical class has no element. For example, round, square, eternal engine, God, witch, and more. A single term is a concept whose scope consists from only one subject, like the city of Kyiv or Ternopil National Economic University, and more. General concept is a concept whose scope consists of more than one subject. The general concepts are person, state, legal norms, rule of law, crime, and many others. General concepts can be registrable and unregistrable. So, registrable concepts include a clearly defined number of items. For example, planet of solar system, part of the world, close relative of the accused, legal representative of the victim, and other. Unregistrable concept is a concept that refers to an unlimited number of items. So the notion of fact, event, essence, phenomenon, and other is not registrable, since the number of items subject to each of them is not accountable. Collective concepts are those concepts that reflect a set of homogeneous objects that are considered as one unit, like forest, library, and many others. There are the concept of also class, crowd, and other. For example, when we tell about the library, like some type of concepts, reflects the essential features of a library as some collection of books, but not only books, yes? Also some paper information, some CD, some internet resources, because library today is very wider concept. Therefore, the collective concept is not applicable to individual items of the aggregate. A collective concept can become both single and general. So, in the term of content, distinguish the concept of concrete and abstract, positive and negative, and correlative and irrelative. So, concrete concept is a concept that reproduced the object in its entirety. An abstract concept that reflects not an object but its property or relation, taken as an independent object of thought. The concept of like table, man, state, theft, crime, and other are concepts which are concrete, and courage, value, guilt, quality, quantity, and many others are abstract concepts. The concrete concept corresponds in reality to a specific object or phenomenon. Property, however, reproduced by an abstract concept has no objectivity. It does not exist by itself beyond the thing. Relevant concepts. There are concepts which reflect such objects, their existence of one of which is impossible without the existence of the other, like debtor and creditor, plaintiff and defendant, cause and effect. Irrelative concepts reflects objects that exist separately and are therefore not perceived through connection and dependence with other objects like enterprise, merchant, and others. And positive and negative contents. So positive are concepts that reflect the presence of an object or phenomenon or certain features. Negative is a concept that refers to the absence of the subject or of signs that make up positive concepts. For example, the notion of condemnation is a positive. Insanity is negative. About content of the concept and composition of the crime. In our juridical life, in our law activity, we used many type of concepts. So, especially in criminal law, along with the term content or the concept, there is a specific notion of the composition of the crime when it comes to a specific crime such as theft, murder. Then they are not talking about the meaning of the concept of theft or murder, but about the composition of the crime, stolen, murder, and others. Each crime is a legal notion about certain social dangers. Under the form of crime is understood as a set of some subjective features in the presence of which socially dangerous action is determined by the crime under the criminal law. Logical side of the crime is the content of the concept, which reflects a particular crime, and the composition of the crime and the meaning of the concept from the same signs of certain socially dangerous action. For example, the meaning of the term robbery is as follows: 1. Open; 2. Theft; 3. Personal property of citizens. So, as we know from the criminal code, robbery is open theft, which personal property of citizens. So, composition of most crimes establishes criminal penalties, but in some cases, the law does not determine the features of the crime. Given this right to criminal law theory and practical jurisprudence, the criminal law offense is the sole basis for criminal liability. Criminal persecution can be violated, and the violated is subject to termination at any stage of the criminal process, if in the act or inactivity of a person there is no crime. In the action of the accused, the available composition of a specific crime only when this act has all the features of this composition of the crime. The absence of at least one of the above mentioned signs of a crime in the presence of all the later means the absence of this crime as a whole. In this case, the committed can be qualified under the article of the law which describes the present crime. For example, the action of the accused does not constitute a crime of theft. To its effect, the concept of theft is not applicable. If here secretly withdrawal from the lawful owner or from the use of third parties, objects that are not property, say documents, because in his action there are no signs of theft. So, secret theft, own property of citizens. In this case, in the action of the accused, there is another form of crime, namely the crime alleged by Article 193 of the Criminal Code of Ukraine. Logically, the classification of a crime is the correlation of a separate socially dangerous act or inaction to a certain class of objects, the application to one of the criminal law concepts, article of the law, provided for law. So, incorrect qualification in the inclusion of an action to a person, to the class of objects, crimes, I mean, to which this action does not actually belong. The application for the object's action of the concept, articles of the certain, the features of which it does not have. Incorrect qualification of a crime. This is a mistake not only judicial but also logical. So, qualification of a crime, one of the main tasks of justice and law activity in general. And very actual question, the types of logical relationship between concepts. Every day we use many types of relationship between various kinds of concepts. So now I represent you general kinds of types from our life and our daily professional activity. So, in the process of the cognition and our practice, it's often necessary to clarify the relationship between certain concepts. Knowledge of relation between concepts makes it possible not to confuse one concept with other, to use correctly the concepts in the practice of thinking. In logic, distinguish comparable and non-comparable concepts. Comparable concepts are concepts that have a common birthmark or a generic concept. Example: law and morality, law and morality, law and decree, contract and agreement, and many others. Non-comparable concepts there are concepts that don't have a generic concept. Example: right and middle, atom and state, rule of law and rule of law and plant, crab and weightlessness, and many other. Comparative concepts are compatible and incompatible. So, compatible concepts are called concepts which the scope of which completely or partly coincides. The concept of compatible concepts is different, but some of their features may be common. Incompatible are the notions whose scope does not fit in any of its parts. Here, the special characteristics of one concept exclude the derivative signs of the second, but the generic sign of incompatible concepts is common. Among the compatible concepts, distinguish three types of relations. So, we have three types of relations between compatible concepts, like identity, subordination, and crossing. So, for the first, about relationship of identity. The scope of identical concepts coincide completely, but the content is different. In the genus same site, a sign of identical concepts is common. So, the scope of identical concepts coincide completely, but the content is different. For example, we have two concepts: A, founder of logic, and B, Aristotle. We know Aristotle like famous ancient Greek philosopher, yes? So, for example, A and B, founder of logic, the concept B, Aristotle, which provide a single area of scope, yes, A and B. So we talked about single scope because Aristotle is a founder of logic. So we tell about one person in two essences. yes, in two essences. So these relations of identity between two scopes. Second type of relationship, the relationship of subordination. The relation of subordination exists between such concepts, one of which is part of the scope of the second. For example, law and state law. We have two concepts: law A and B, state law. So, as you know, law have many branches, more than 20 branches. Yes. So, state law only one of all kinds of branches and only one element of scope of the concept law. So on this picture you may see two areas, two around, like area A, larger, and area B, like element of the area A. Yes. So A, all law, all branches of law, and B, only one branches from this area, from this logical class, as you know. Yes. So the relations of subordination can be between two general and between general and single concepts. If the relation of subordination exists between general concepts, then the subordinate concept is called generic, and subordinated a kind or a specific notion. Thus, the notion of law is generic, and the term civil law or state law in our situation is a type or one of the kinds of the generic concept of law. Next type of relations, like relations of the crossing. Relation of the crossing, the relation of crosswords or relation of the crossing are called concepts, the scope of which only partly enters into each other. So, concepts, the scope of which only partly enters into each other. So, example: A, lawyer, and B, defender. Lawyer and B, defender. Two areas which cross, yes, between each other. So, A, lawyer, and B, defender or researcher. Yes, the researcher, I mean. Yes. So now, as we see, lawyer may be in this situation researcher or defender, and the defender may be also lawyer. Yes. So, for example, other examples like students and a singer, or a researcher and sportsman, and many other types of this situation. So it was a relationship of the crossing. Among incompatible concepts, distinguish that kinds of relations. So types of relations between incompatible concepts, like subordination of the subordination, second, contradiction, and third, opposition. Subordination of the subordination exists between two or more incompatible specific concepts, the scope of which are broadly generic, to which they are equality subordinate. So, we have example: theft and robbery. So the area, general area A, B, theft, and C, robbery, we have some generic concept A, which we may name this general area A like kinds of crime or crimes, yes, crimes and theft and robbery. We have two independent kinds of crimes according to the criminal code. Yes, so these two concepts, only two elements from other general types of crimes which consist in the criminal code and criminal law. So the scope of subordinated concepts does not coincide in any of its parts. Very interesting, and this logic is important for criminal legal theory and jurisprudence. So we tell about two independent concepts. Next, the relation of opposition. Relations of opposition exists between two concepts, one of which is denied by the second with the help of the establishment of new features that are incompatible with the features of a definite concept. Yes. So, example. We make some general area, so A like revolution and B counter-revolution. So A and B in this situation, the content of one opposite concept not only exclude the content of the second, but also the opposite of it. Therefore, opposite concept can be applied to the same subject at the same time. It's impossible, for example, to say that this subject is both white and black. That also we have many other colors, yes, blue, yellow, orange, red, green, and many other types of colors, not only black and white. Yes, from law activity, from the legal, from the law theory, I may propose to you such example like types of state territorial system. We have unitary state, federation, and confederation. Yes, according to this picture, to this scheme, we have also this area like types or kinds of state territorial system, and A confederation, B a unitary state, and this narrow like C. I named this chapter of this area like C. So C like federation. So we have some opposite A and B opposite concepts in this type of relationship between concepts. The scope of the two opposite concepts don't exhaust the scope of the generic concept. Between them may be the third concept. So, if the death of the victim is not an accident, then it does not follow that there is a matter. Yes, the victim's death could be the result of self-destruction. Like some example from the criminal law, from the criminal situation. Yes. So, and number 6, next type of relations between concepts, like a relation of contradiction, exists between such two concepts, one of which has certain features And the second, the same signs deny, not claiming anything new. So, example, A, guilty, and B, innocent. Guilty and innocent. The content of one of the contradictionary concepts is a combination of certain attributes, and the content of the second one is a denial of these particular attributes. Scopes of contradictory concepts exclude each other. So the scope of contradictory concepts exhausts the entire scope of the brand concept. In addition to date of contradictory concepts, the genus does not have any intermediate third concept. This provision of logic is important for criminal law theory and judicial practice, not only criminal but for all branches law and spheres of legal activity. So in this type of relations, we may tell about two opposite type of concepts according to this content, but the general area consists only two types, only two opposite types of concepts, and third types, no third types in this situation, because some person may be guilty or innocent. Yes, the third type, no third situation in this example. So, like some conclusions. Thus, knowing the relations between concepts is important for lawyers. The terminology of legal science is quite complicated. For perfect mastery of it, it's necessary to carry out a logical analysis of the structure of legal concepts and to give them a logical description. However, the qualified professional must also be able to correctly identify the relationship between these concepts and know all types of concept and some mechanisms and methods which may provide these kinds of these logical theory and in law practice and juridical activity in our professional daily life and our professional juridical life. Thank you very much and goodbye.